Alpha OneTV, subscribe and share more news so the any bintin on to keep you updated. In summer, a fa Akwatia a case in home and just in Sake be a de Bremo. Na we know a NDC a lawyer with Jeremoma a Akwatia NDC parliamentary candidate and just a dimunche Jimo abre kama pa dear course or court or Supreme Court or near their dinina or Tonoboas a na areho sema still na that's what that this NPP Akwatia MP NSKumi as one say Supreme Court enyi ayekoforo dia ruling in free so court bia kwashe that ruling no dia amomoko dia court the ruling by ni say yenti na asem but it doesn't mean so ma kwashe Supreme Court sorry koforo dia high court ruling na togu so still na that ruling and that's what ta NSKumi na pampema enya asem keton afin so a Supreme Court judge NDC say a year back a day a ruling against even this NSKumi semi-crack can ruling against him arches or chase uncle face emrano nem running in D arches enyas and to encasabe brain connecting cinnamon chichimu
on why he wants the court to quash the conviction of the Koforidua High Court. We've got updates for you on this particular one here on Ghana Tonight, and also the reaction so far to this particular position and decision taken by the courts. The Supreme Court earlier today has in a 4-1 majority decision ruled that it will hear the case of the Akwatia Member of Parliament, NSC Alkumi, despite his contempt conviction by the Koforidua High Court. Lawyers of the Akwatia legislator filed a motion seeking to set aside the decision of the High Court without first purging himself of contempt. So, but the court first had to make a decision whether to hear him. Now, having made that decision today, the court will hear him on his case on the 26th of March. Bernard Bediako Bedo is lawyer for the Petitioner. That's the NDC parliamentary candidate in the Akwatia constituency, and he's going to be joining us on the telephone shortly to have a conversation on the developments so far. But what we do know is that Justice Gabriel Pwamang dissented, so he was the only dissenting judge on this case, and the four went the same direction. So that's the development on this right now. And let's go on to the telephone now, and we're joined by the lawyer for the petitioner, the NDC parliamentary candidate for the Akwatia constituency, joining us right now. Appreciate your time. Thank you very much, Counsel. For good evening.
Good evening. Thanks for having.
Great. Now, today the court took a decision, and was there did you make a case as to the path that the court took today in ruling that despite the Akwatia MP not purging himself of contempt, he still should be given a hearing?
Okay, so you'll recall that at the last hearing date, this matter came up, and it had to do with whether the contemnor, he is not an alleged contemnor any longer because he's still a convict. No court has vacated that conviction. So the contemnor should be given a hearing or not. Remember that was, that came from the bench. I or my client or no other party, brought this up. We were ready for the application, and from the bench, when I say the bench, the judges then put that to him, whether he should be given a hearing or not. Back and forth, we were asked to, submit address the court on whether he should be granted a hearing or not. Now, when we left, we were of the considered opinion. Now, you would also recall that just before we left court on that day, there was this viva voce. When you say viva voce, an oral application by counsel for the contemnor applicant at the Supreme Court that the relief they were seeking in the substantive application, the judges should grant, or the court should grant that relief as an interlocutory or interim relief, so that the hands of the High Court judge is tied and so that he doesn't proceed to sentence the contemnor. I mean, even before the Supreme Court hears the application. So that in itself, in our considered opinion, was a hearing they had offered him, because you see, if the application is seeking to invoke the court's jurisdiction to tie the hands of the learned High Court judge from sentencing him, and that application is granted when they had not even filed an application properly so-called. In fact, the main application had not even been served on us. So I got up and told the court that we had not even seen the application, because it was that morning they sought a statutory service application for the processes to be served on me in open court, and the order had not been drawn. So I had not cited the processes. I told the court, and by a decision of 4-1, they said they would still, I mean, when I say tie the hands of the learned High Court judge, you understand, so he doesn't proceed. So we were of the considered opinion that there was no need to file anything. Indeed, we are also not against him being heard. In fact, that's why we are in court. We want him to be heard so that we can respond to it, because we know the case we are presenting. A lot of factual inaccuracies have been put out in their case. That's our view. And we are looking forward for an opportunity where we would correct the factual inaccuracies and the law. And so we were prepared. So we didn't file anything. In essence, we were not opposed to him being heard. So when the case was called today, yes, the court asked whether we had filed anything, because they had filed yesterday and we were set. And we told the court that no, and that we leave the decision whether he should be heard or not, because it came from the bench. It didn't originate from our end. So we told the court that for us, we have no problem if we are prepared for the application. So if he will be heard, we are prepared to proceed with it and answer to whatever application they will put forward. And so we leave it to their discretion. And so it was not opposed by us. We didn't file anything in opposition because we want him to be heard. And then we would have an opportunity.
So essentially, you defer to the wisdom of the courts in this matter?
Absolutely. We defer to the wisdom of the judges in this matter. And so they ruled that by a majority decision of 4-1, they ruled that he be heard. In fact, when counsel started, he was going into the matter, but he was asked by the bench not to, because the matter is the reason we are here. And that whether you should even be heard in the matter or not is what we are here to determine. So going into it would not help. In fact, that is what I came in to say, that if it is going into the matter, we are prepared. But at that stage, we were considering, or the court was considering, whether to even grant him a hearing, which we are not opposed. So if it is the hearing that they are seeking, we leave it to the superior. We say always that their wisdom is superior. These are the law lords. And so that's what happened.
So the hearing for the substantive case is what is going to be heard on the 26th of March?
Absolutely.
Okay, but how about the contempt case as well? When is it going to be heard?
So there are two applications, and both are going to be heard on the same day, the 26th. I mean, there's a certiorari application filed on the 8th, 2 days after he disobeyed the court, on the 8th of January. And that matter, that one has to do with the interim injunction, where he says that the court didn't have jurisdiction to even grant the interim injunction. And so that is one. And then the conviction on with regards to the committal for contempt. And so there are two different applications. And usually when we go to court, we do both. So one is called and the other, even though they are some ways linked. And so if your reporters were in court, they would realize that at the tail end of the session, lawyer Gary, the lawyer for the contempt applicant, prayed the court for a consolidation of both cases because they have similarities. But the court said it's not something they would consider now, but when we come, we would determine it. We have a view on that, but when the time comes, we will express it. So on the 26th, both applications will be heard. That's 2 weeks from today.
I see. Well, we'll wait for that date. And so we have two cases to be heard on this, the 26th of March. That's the substantive case and then also the contempt case as well, also on the 26th.
All right, yes, but well, maybe for lack of a better word, the substantive, you see, because what he filed was, yes, what he filed was an application with regards to a certiorari, judicial review in the form of certiorari against the interim order, the interim injunction.
Okay.
You see, I would prefer you use that because there are other issues. If you say the substantive matter, we have our issues with that. It is on the interim injunction.
Okay. And so, in fact, it's just some 2 weeks away from now, so we'll see how things play out on it. But I thank you very much for also having to speak to us and bring some perspective to what happened in court earlier today. We get the understanding that the full ruling will be made available by the 21st of March, correct?
That is true. That is so. That is so. You know, there will be, of course, there is a dissenting ruling as well. So there will be that for the dissenting and then the majority as well. So the 4-1 both would have its own reasoning, and that will be available for us. And going forward, you see, whatever happens at the Supreme Court becomes a guide to the lower courts, okay, because of the hierarchy of the court system. And so beyond every other thing, we would take a cue from it. So it's good you go for a copy, read it, so that whatever it is, you will be guided going forward. So it is not always about where it falls. It is also about learning. Yes, we do not really, and I must emphasize that we have never had any problem with him being heard because we know the case we have. And so we want him to be heard so we can respond. That is what we have always been praying for. But the court has its own decision. So we abide by their wisdom.
Okay. Thank you very much for joining us. Lawyer Bernard Bediakon Bedu is counsel for the NDC parliamentary candidate for the Akwatia constituency, the petitioner in this case that we're talking about. Thank you so much for joining us here on Ghana Tonight. And those 2 dates is one that we'll watch. But coming up next here on
Obviously, for Niema Bibrina na Air Koso, Niema Bibrina na court, especially the Supreme Court, a man for Sweden, Kawasem. Any ruling from the Supreme Court, Biano, Eani Yamagana. Ni bia enyama all the lower courts ni nyina because ruling no be ruling na a guiding the lower court to learn. So some of the ruling ba that's enya Ghana we are in the wrong direction. Some of the ruling ba that's just a Ghana we are in the right direction. That was the reason why a GM a caution say ban election related matters now. I'm making sure say the truth best standing justice be prevail because sano ne omadwin amodi kan sem ne di ruling bano if say they are doing things to favor some political party be kutwa be mark daho say even the lower court esua the yomoniema so mun yomadwin say they are there because of partisan omunyo madwin so mo ye niema dia favor obi omunyo madwin omuniema any fan favor Ghana mum na beboa because any their wrongdoers bia no it means Ghana bebia ye ni kire na enye baby papa so we no mokoi no they were there just for NS kumina udani dwana no sana NDC for edibetu just say ye man bail for omba ko for the high court frena omba udani so we no we crampono NDC for kase omumpa ibo na bem because ruling na Supreme Court the bind say onkoni engo tie na asem yenti na asem na e court mfangina so emfa ruling bra ko for the high court ruling not the bind no na yenyanti and skumi side of the story but na omba ne chese de the panel the case in the biano e begina no so nkwaa den et ruling aba because brabe ka wan samomba omba dia case na e court no ne begina so the ruling aba so you see na wadwane no akọ Supreme Court and court say go back na for the akoforo the high court here de emma chance nie afide ko ka won sem no munti no munjina so mfa ruling bra. So next 2 weeks and actually omudi another ruling beba say yen kwahye eye case na say ruling na Koforidua High Court de beta na pampam yen kwahye anase ni ankwahye. Because as you speaking in the utie lawyer near or dinchichemu ni buy no say still no is a mark on this and is kumi say still no that ruling I say yen sentencing in prison no still na that's done so court be no way everywhere still na that's done so to be no bit much na court be no way everywhere court be no akwahye that ruling na togu till say so much date no machine next 2 weeks in beba no and no any be say court be kwahye anase nkwahye. So it is surprising speaking of that and is community cramp no Koforidua High Court ruling that's what na pampem one Supreme Court judge a ruling against him said do enye any mutre a ruling in favor of him say yentie na asem ye man another chance ne inti nasam and when a case na kwa kudru. So NDC for next action be taking in no elo eni achichi mu ya chain said the case no komomo said the mukuta all the evidence fact ni nyine kuta omo make sure that the right thing must be done. Justice must prevail no matter all the circumstances or some making sure that the right thing must be done. So when you say oh kunim Supreme Court say on konin kuti o masem debi nye no no pe say this MP then the fact eba the intina court catch us say the injunction at all. So yes or no when book court and move forward ekotena parliament and my swell in knowing say a banisa a becomes a punishment kese den or still now so book court ruling and then hope said the same court ruling a ruling ma now with me the enya hoto Ghana hano odwene me bi kwa chira wonti ase yet all the fact any NDC for next action nyina any ayensu sanso da o ma this Akwatia MP subscribe na share ma nua so de enye binti Akroma.